Well, good afternoon, everybody. I'm very gratified, actually, is the word. I've just seen the attendees list shoot from 0 up to 101, which is phenomenal, and I'm really delighted with that. And thank you so much, everybody, for tuning in to. It's actually our first webinar with the ISACA Ireland chapter, and we're delighted, absolutely delighted, to have got to this stage. We're very pleased that this first webinar is being presented by David Fagan and his colleague Gail Chalmin from Business Legal. David has been a presenter at our conferences in the past, and he's an absolute treasure trove of information relating to data protection, the GDPR, privacy in general. He's been practicing in that area for I won't say how long, David, many years, and has developed tremendous expertise. So I'm certainly looking forward. I think we're all really looking forward to getting a lot of info from this session. We've all adapted and I suppose developed a certain comfort, if you like, with the presence of GDPR in our lives, but it really will be good to get an insight into how it looks now that it's 2 years in operation. And Dave will be starting shortly. Just for the ISACA members who are present, we'll be issuing a newsletter in the next day or two, which will update on a lot of things. You should see in your screen a chat, a bot. Sorry, no, I'm having a bit of return of sound there through another screen. You should see a chat button at the bottom of your screen, and this will allow you to ask questions from the panelists. So please feel free to put in any question that does come to you, and there may be some repetition of questions, but Gail and I and my colleague Herman from the ISACA Ireland chapter will be keeping an eye on the questions, and we will present them. David has built in time for questions towards the end of the presentation. So without further ado, David, I'll hand it over to you, and please take it from here.
Great. So I'm sharing now a set of slides. I think they're up there for everybody to see. And I'll just make sure they're actually, can you see them there, Fergal? They're up there?
I can see them. I hope everybody else can.
Great. That's fine. There was a little green tick beside them, or a green box around them before, and it's disappeared, so I wasn't sure if they were still live. So, as Fergal said, I'm David Fagan from Business Legal. My background is as a commercial lawyer. I was formerly the head of the Data Protection Privacy Unit in Eversheds, which is, I think, still currently Europe's largest law firm, based in Dublin, for myself. And I come at this from a legal perspective because at the end of the day, the regulation is a piece of law. Ultimately, there are lots of disciplines involved, but ultimately it's a piece of law. I hate to say, but I am involved in the data protection area for the last quarter of a century. Fergal was kind not to say how long, but unfortunately I've been at it that long. That's not to say I know everything, nobody does, but I've come across quite a few things in my time, and I'm happy at any stage for people to ask questions, and Gail or Fergal will moderate and pass questions to me. I'm happy to tackle them on the fly, also happy to tackle them at the end. And indeed, I look forward to hearing a lot of questions, because one of the main things is that we all experience what we come across, but everyone else's experiences that might be different to ours. And it's very interesting cross-fertilization that goes on at these types of events where you hear these specific issues and the specific engagements that other experts, colleagues, companies have in engagements, either with data subjects, with processes, with controllers, or indeed with the DPC or other regulators. So without further ado, I'm going to kick off. What I'm going to do is and has my slide changed, Fergal, just to confirm?
Yes, yes,
Yeah,
it has, David.
So I'm going to kick off. The reason I ask is sometimes these things freeze on one machine and they're moving for me, but not for everybody else. So I'm going to kick off. The way I'm going to structure this is I am going to have a brief whistle stop through the GDPR. Most of us have a very good understanding of it, so I'm not proposing to go through it as a GDPR seminar. The key point of this seminar is to discuss where we are 2 years on, what's coming down the tracks. But just as a brief highlights of the GDPR, key points for me of the GDPR, Article 5 in terms of processing. So if you're going to process any data, most of us know that it has to be lawful, fair, transparent, essentially lawful in the sense that the processing must have certain legitimized as fair, which is a kind of a catch-all, but I suppose so that the data subject knows or that you're doing things that the data subject would expect that you're doing. Transparent in terms of the notices and notifications you're required to give under Article 13, 14, 15. And then that the processing must be specified so that what you've told the data subject you're doing is what you're going to do. It must be explicit, it mustn't be ambiguous, it must be for legitimate purpose as set out in the next article, which is Article 6. It must be adequate, so there must be enough information there. It must be relevant to what you have to do. It must be limited, that is to say, you're not allowed to collect more data than is necessary for you to do the job that you're trying to do. It must be kept accurate, must be kept secure, and most importantly, must be retained for no longer than is necessary. Whistle stop through Article 5. When you're processing data, and you'll find it in the best source of information is the GDPR itself. When you're looking to process data, most of you know you have to comply with everything that's in Article 5. There's no exceptions. You must touch all of these touchstones. If you don't hit them all, then you're not processing lawfully. In addition to that, you must also process any data that you process must also be based on one of the factors in Article 6. So everything in Article 5, you must hit all of those marks, but you must also have one from a list in Article 6. That list essentially, and I've truncated it very heavily, consent of the data subject, or that the processing is necessary for a contract that you have with the data subject, or that you're legally obliged to process in some way, so there is a law or some other obligation requiring you, other than by contract. So a court has ordered you to do something, or there's a piece of legislation that requires you to do something, or alternatively that it's in the vital interest of a natural person. So not the vital interest of a company, but the vital interest of some individual, not necessarily the data subject, or that it's in the public interest, or that it's being exercised by somebody who is vested with official authority to process this data. And lastly, the catch-all, and the one that's most useful, that it's in the legitimate interest of the controller, the person processing the data, the person who decides how the data is to be used. So essentially, the way in which it works is you've got to hit all of these marks in Article 5. It must be lawful, it must be fair, it must be transparent, it must be for specified, explicit, legitimate purpose. The data must be adequate for the purpose. It must be relevant to the purpose. It be limited to no more than is necessary to achieve the purpose. It must be kept accurate. It must be kept secure, and it must be retained for no longer than necessary. Plus one of this list, either consent or necessary for contract, or because of a legal obligation, or because it's in the vital interest of an individual, or because it's in the public interest, or it's in the exercise of an official authority vested in an official, or it's in the legitimate interest of the controller. So any data you're going to process at any stage has to meet all of that Article 5 list and one of that list in the slide that's in front of you. And if you are going to do something that's based on special category data, that's data like health data, biometric data, genetic data, data on political opinions, religious and philosophical opinions. If you're a trade union membership, if you're going to use data that relates to one of those very narrow types of ground or interest, you must, in addition to everything that I've mentioned in Article 5 and one of those things in Article 6, you must also add one more element to the list, one from this list, which is explicit consent. So the consent, if you're using consent under Article 6, it now must be explicit. Explicit just means that it's stated. So explicit consent is consent that's stated. You can have an implied consent. If all of the circumstances are such that it appears that someone is consenting to something, but they haven't actually said so, that's an implied consent, and that's fine if it's not special category data. But if it is special category data, it must be explicit. So it's in a memo, it's in an email, they've ticked a box, they've said something, it's expressed as opposed to implicit. Alternatively, if you want to process special category data, instead of just being necessary for performing a contract with the data subject, now it actually has to be necessary employment or social security or social protection. So really it's only relevant to employees. So you can't contract into this. Or it must be necessary because of a legal obligation, or it must be in the vital interest of a natural person who is incapable of giving consent. So you can see that it's similar to the previous list in Article 6. It's just not just a vital interest of a natural person, but there's an extra step. That must be a natural person incapable of giving consent. So a minor or somebody else who is in some way not capable of consenting. Or it's for a not-profit body in respect of their members, or for the establishment or defense of legal claims, or that it's in the public interest, but not only in the public interest, it's in the substantial public interest. So if you want to process any of those special category data, you've got an extra hurdle. It doesn't mean it can't be processed, it just means that the situations in which it can be processed are much reduced. And lastly, you can process special category data if it's data that's already been made public by the data subject. But this, and I want to pause and say this slowly because it's something that's vastly misunderstood. I've referred to 3 times already that you have this kind of bucket, everything in Article 5 if you want to process any sort of personal data, and one of Article 6 if you want to process any personal data. And then I've said, but if you want to process special category data, you need something from Article 9, the list that's up in front of you. But I want to explain one of those, which is the data already made public by data subject. People assume that just because they have data which is already being made public by the data subject, this allows them to process it. But that's not the case. It only means that if they've already complied with Article 5, that big long list with everything, and complied with Article 6, as in one of that second list, which is just there, consent, necessary contract, legal obligation, etc. It's only if they've complied with all of those that they're allowed to process it at all. But if they are allowed to process it at all, and it has already been made public by the data subject, then the fact that it is special category data does not impose any additional bar. In other words, once the data subject has made it available, it's available to be used as long as it can otherwise be processed lawfully. That's actually how the GDPR works. In its most basic form, if people only had recourse to Article 5, 6, and 9, it would actually tell you how data should be processed. I know there's an awful lot more in it, but that's actually the basics. That's where the nuts and bolts of the GDPR are. So as I say, in special category data, you need an additional lawful basis. So you need everything in Article 5, you need something from Article 6, and you need one of that additional list. And if the lawful basis is consent, and this is a bugbear, that consent must be explicit. So there is implied consent in the GDPR, but it's just not implied consent for special category data. And lastly, what's missing from that list in Article 9, special category data, the main thing that's missing is legitimate interest. You cannot process special category data just because it's in your legitimate interest to do so. You need one of the much tighter criteria that are set out in Article 9. Legitimate interest is probably the widest ground available to a controller, and that's not available for special category data. So, key points of the GDPR. holistically, you need a lawful basis when you're collecting data. So at the start of the process, you need a lawful basis for collecting the data. You need a lawful basis for processing the data. You can only process that data as long as a lawful basis exists. And essentially, in a nutshell, get as little as you need, keep it only for as long as is necessary, and keep it secure. It's all about as little as controlled as possible. That's the thinking behind the GDPR. The reason I make a big fuss about lawful basis for collection is that it is not uncommon for me to be asked a question by somebody performing marketing or any other function in a company saying, we want to do X, Y, or Z with our database. We want to transfer our database to Bolivia. Is that lawful? And the answer usually is yes. No matter where it's going, you can put in legitimate safeguards, model clauses or standard contractual clauses, as they're known, to legitimize the transfer of data outside the EU. But people forget that just because, for instance, a particular type of processing might be necessary, the question always arises, did you validly get this data in the first place? And I've seen on many a project where the actual processing is perfectly lawful, but the data that's already being held is unlawful, should not be continued to be held. So it's not that what they're proposing to do it now is unlawful, it's the fact that they have the data in the first place is unlawful because it wasn't collected for that purpose or whatever. And this is my last, I think, point on the GDPR. As I say, we don't want to turn this into a GDPR seminar or webinar. We want to look to the future. Marketing, it's a particularly important subset. Where we are at the moment is that we still have the 2011 electronic privacy regulations. So in broad brush, nothing has changed in marketing other than the changes that came around in 2018 when the GDPR came in. Essentially, you can postal market to anybody until they object. You can electronically market to businesses, but not to consumers until they object. But if you want to market to individuals, you must get their prior opt-in consent. Now there is a new regulation, which I think most of us are aware of. It was originally planned to be enforced at the time of the GDPR coming in, 25th of May 2018. It was always intended that the regulation would, that the two regulations would land at the same time. They didn't. The e-privacy regulation, this is European Union regulation, is still stuck. The last thing that happened was the European Council, effectively the member states, tried to or have loosened up the draft to allow for legitimate interest as a reason, amongst other things, to market, and that will then go back through the tri-party process, go through the washing machine again, get watered down again. So at the moment it's still in a limbo, and there's probably no point in saying anything more than that. It's not showing any immediate sign of coming to a conclusion. So for the moment we are stuck with the old e-privacy directive, well, it's effectively the cookies directive as well, and these e-privacy statutory instruments regulations in Ireland. Key point though, with the dovetailing of the marketing regulations and the GDPR, consent under the marketing regulations is now required to be in line or compliant with GDPR. So when we're talking about consent under the marketing regulations, we're talking about consent under the standard of GDPR. Essentially for marketing, that is removed, as most of people will know, the ability to have pre-tick boxes. There must be some form of positive affirmation of consent. One minor point, always remember that this is about consent. So there can be other things where people pre-tick a box. They're not being asked for the consent, they're being asked for something else. So you will still see pre-populated boxes, but not to ask for consent for processing. So it's not automatically wrong if you see a pre-ticked box on a web form. You just have to make sure that what it's not doing is looking for some form of consent. It could be pre-ticked for something else. For instance, it could be pre-ticking the jurisdictions in which you say you operate. for some reason. You know, do you operate in any of these following areas? You know, they're trying to gather information, or they want to know, they want to know something to do with their processes, and they're just giving tick boxes for some technical reason to explain something technical. Yes, so yes, such and such a switch is on, or such and such a switch is off. That's not asking for consent. So there's nothing wrong with that sort of pre-ticking of boxes. It's only in relation to consent. So some key case law, getting into where we are and where we're going. I suppose the big case in GDPR terms is Schrems 2, Schrems versus Facebook. Most of you will know that Max Schrems took a previous case many years ago, managed to invalidate the safe harbor regime, which allowed for transfer to the US of data without standard contractual clauses and without an adequacy ruling from the European Union Commission. And that was invalidated, was replaced by Privacy Shield. Max Schrems is still having a fight with the regulation, and his current target in Schrems 2 is the standard contractual clauses or model clauses. So the case has gone through the Irish High Court. It's got as far as the Advocate General in the Court of Justice of the European Union. The way in which that system works, for those people that don't know, is that when a case goes to either the European Court of Justice or the Court of Justice of the European Union, one is basically for, I suppose, administrative and national bodies, and one is for, you know, the world and his wife. Effectively, they're pretty much the same body in essentially with different names. But the way in which the system works is that the case is heard, both parties get their say, and then the Advocate General makes a decision, and his decision or ruling is not binding. It's essentially indicative. So it's kind of like a pre-run through the circumstances of the case, and the Advocate General's decision is typically followed by the main court. So it's by no means unheard of to be departed from, but mostly the Advocate General's research work and discussions in his decision or her decision is mostly followed by the court. So it's not an absolute decision, but it's good guidance as to where the court is going to end up. So the Advocate General, in this case, said that Privacy Shield was suspect, that's the transfer mechanism to the United States, but that as it wasn't a direct element of the case, it probably should not be addressed by the main court. And if it was going to be addressed by the main court, it should be addressed in abstract terms. So that, if that is followed, we will either not have any decision on Privacy Shield, which just means it just remains out there for some other case, or that if there is, it'll be a very generalized abstract one, possibly making some high-level comments. Separately, he made some other comments, and I want to come to those later in a further slide. But the actual Court of Justice European Union decision is slated for the 16th of July, and that will go ahead. It's not going to be delayed by COVID. So on the 16th of July, the Schrems case, we will know whether standard contractual clauses are valid, and we might find out some interesting commentary about the Data Protection Commission, because the Advocate General had quite a few things to say about the DPC and how it ran the initial stages of this investigation into Facebook. Second interesting case, interesting primarily because of the size of the fine, is ICO versus British Airways. A 204.6 million euro fine. Now, you'll be aware that the penalty limits for administrative fines are either 20 million euro or a maximum of 4% of global turnover, global annual turnover, or 10 million or 2% of global annual turnover of a company. So the reason this fine was so large was because of the size of the global annual turnover. It's obviously 10 times, it's actually 20 times the 10 million limit which would apply to that. That case is still under appeal, but it's a fairly hefty fine. And if something of that were confirmed, and obviously in the meantime, the UK has left the European Union, which is something of an irony, that the largest EU fine is from an exiting country, but it gives a sense, I suppose, of the potential for very large fines under the GDPR. It's not just about the 10 million or 20 million limit. Another interesting case also from the UK, in the Morrisons case, effectively Morrisons were held responsible for the actions of a rogue employee. Essentially, what the employee did was nothing to do with company policy. But GDPR is not necessarily about company policy, it's about the protection of data, and they had failed to protect employees' data, and it was quite an egregious breach involving the giving out of bank details and so on and so forth in relation to a wide range of employees by a disgruntled employee. It was quite an egregious breach, and they were held liable. So where's the focus of the DPC up to now? DPC in Ireland. Up to now, the DPC has concentrated on big ticket cases. There really isn't a huge appetite in the DPC to go after SMEs. They do go after them, but it's mostly as a result of complaints from the public. The actions that the DPC has initiated and focused upon are the Facebooks, Twitters, WhatsApps, etc. of this world. And there has been a lot of complaints, not least by Mr. Schrems, but also by some of the other supervisory authorities, the other DPCs around Europe, have complained about the way in which the DPC here has done its business. Effectively, our first fine was only issued last month, I think. Last month was May, wasn't it? It's fairly recently. We haven't really, I think we were the second last jurisdiction to come on the scoreboard for issuing a fine. And I think the last jurisdiction is actually Luxembourg. And between Ireland and Luxembourg, pretty much all of the large social media companies are regulated because of the one-stop shop. They're not regulated in every jurisdiction. They're only regulated in the lead jurisdiction. And essentially in Ireland or Luxembourg have 90% of that market, for want of a better phrase. So there is a feeling and a complaint that perhaps we're going easy on these companies because they bring a lot of revenue into Ireland and so on and so forth. Obviously, the GPC utterly rejects that, but certainly, that complaint has been made more than once. Another focus for the DPC is is what might be described as easy compliance. They've done it before and they're doing it now, by which I mean many years ago, before the GDPR came in, the DPC targeted 100 websites on the basis of their privacy policies. So it basically just took a random sample of 100 websites and said, we don't like your policies, and they published them on the list, and they said, we don't like your policies, and we'll move to enforce in a little while. So it was a very cheap win for them because companies named on that list scrambled to get their policies in order. And the DPC didn't have to go and spend money investigating any more than just looking at a few websites. And of course, everybody else thought, well, I could be next. So it was a very cheap win for the DPC, and they are doing that again. They've done that with a cookies report. They've looked at a number of companies and controllers and processors, and the level of compliance was astonishingly low. I think they found 2 compliant companies in their search, and they only searched something less than 50 companies. So only 2 were compliant. And I should talk maybe a little bit about that, in that back in the day when GDPR was coming in, the mode du jour of cookie policies was either to have a generalized cookie policies that said something like, well, we use session cookies, we use third-party cookies, we use marketing cookies, and in broad brush, this is what they do. And if you want to turn them off, well, go to your browser, and your browser can set these for you, and possibly a link to Chrome or Edge or any of the Brave or any of the other browsers, and say, this is how you do it. So it's essentially a one-size-fits-all. It was very easy to do, could almost be standardized for everybody. Some companies went a bit further and named the cookies that they use. So you'd see a list of cookies. So we use Google Analytics, we use this, we use that, and there'd be a list of cookies so people could see what was actually being set. But when the GDPR was coming into force, there was a proliferation then of dashboards where you could, and we've all seen these, they can be turned on and off, and that became more common. But the cost of those dashboards was prohibitive. Initially, when they came out, companies were offering this service for tens of thousands of euros. So quite a few companies decided this was not a cost-effective proposition for them. In the meantime, a couple of things have happened since GDPR has come in. One of them is that the European Data Protection Board have come out with its opinion, and there have been a number of decisions, the upshot of which essentially the current position of the authorities is that you must have granular control of cookies. Essentially, they've made it a requirement pretty much for dashboards to be in use. The positive thing is many of these dashboards have now come down to a point where they're free or close to free. So at the same time as dashboards became an absolute obligation, and the cost of putting them in came down very significantly. So that's another focus, the current, most recent focus of the DPC, as I say, to target just looking based on websites. They also target high-profile breaches. They're overwhelmed in the DPC with low-level breaches. They can't handle them all. They don't have the ability to handle them all, and they don't want to handle them all. So you'll get no thanks for swamping the DPC with the breach where somebody's minor detail that could be found from a quick search in the web escaped into the wild, and there were 5 people that this affected. Not particularly sensitive information of a very low number of data subjects. DPC won't be thrilled if you go reporting it to them and they have to take up time. That's not to say you can't report it to them, but they won't be too impressed. They're trying to focus on high-profile breaches, and they're trying to reserve their resources. Now, I'm going to mention one thing, only in terms of that cookie report, and simply because, as Fergal knows, there is a side business to Business Legal, and Fergus has graciously loudly to make this 30-second, I suppose, mention of it. When companies are based outside of the European Union but are targeting residents in the European Union, they are required to have an Article 27 representative, an European representative, and we have a sister company, EU Rep, which does this business. It is one of the easiest ways to show to a regulator that you are not compliant, because just like the DPC in the past looked at privacy policies to see were you compliant, and more recently is looking at cookies to see are you compliant, and it's a very easy test for them to do. They can also look and see if you're based outside of the European Union, but you are obviously targeting EU residents, either in your marketing or the products that you're selling, you're obviously selling into the EU in some way, shape, or form. So it's very easy for the DPC or any other regulator to spot that you're caught by Article 27 and that you are not compliant. So in terms of the DPC's report, the vast majority of controllers examined were non-compliant. I think there was just under 50. Actually, Gail, who's here, might be speaking later, certainly will be responding on chat, might have the exact number, but it was a low number, but the number who were actually compliant was 2 people. That's a shockingly low number. And as I say, they've previously done such sweeps. It's a very easy win. So it's the easiest win for the DPC. The easiest win for the DPC in all cases is to target a controller or processor based on their public face. They don't even have to go to the trouble of engaging with them in order to see your privacy statement or privacy notice, your cookies notice, cookies compliance, and if required, if you're based outside the European Union, your Article 27 compliance. It's easy peasy stuff for them. Some common compliance issues. What we found in the 2 years in assisting companies with compliance. The obvious one of the lawfulness of the collection and processing, that effectively is their Article 30 compliance, to see what are they processing, have they got the information lawfully, is what they're doing lawful. It varies greatly, obviously, from company to company as to the basis on which it's lawful. But if you haven't considered your data from a lawfulness perspective, there's a fair chance that some of the processing is not lawful. I mean, it stands to reason if you haven't looked at it to see if it's lawful, chances are some of it won't be. Next one is the transparency piece. You are required as a controller to put in place privacy notices or privacy statements or privacy policies, call them what you wish, but essentially you must set out for data subjects how you're processing your data, who's processing it for you, what jurisdictions, and a whole host of other information that's set out in Article 12, 13, 14. Again, very easy for the DPC to look at your privacy notice, privacy statement, privacy policy, call it what you will, and find out if you are breaking the law, because this is information that you're meant to be telling data subjects. Now, you don't have to tell them on a website, but it's usually the easiest way. And usually what happens is you give this information and it's on your website, so the DPC can very easily see whether or not you are compliant. It doesn't have to really do much of an audit just to click on your site and find out. Same with the cookies and cookies notice. Other compliance issues: controller process agreements, model clause agreements, privacy shield issues. If you're transferring data outside of the European Union, it must either be to a country that's approved by the European Union Commission. There is 10 or 11 of them at the moment. And failing that, it must be either at the basis of the data subject's consent, or it must be on the basis of controller process agreements, model clause agreements, or if it's going to the United States, it can be under what's called privacy shield. There are also some limited derogations, and I haven't put it on the slide, but I'm just going to say one thing about the derogations. If you have to use the derogations, or if you're going to use the derogations, it's actually much more trouble than putting in place a controller process agreement, because you have to look at the data and see, is it legitimate to do? There's a whole list of, I suppose, of a checklist to see whether you can get this derogation. It's much easier just to execute a controller process agreement with whoever's processing the data. Far simpler. And some of the derogations are what I call kind of last gasp derogations, where you actually have to notify the DPC of your use of those derogations. So you've got to go through a whole rigmarole just to be kind of to be lawfully able to transfer data, when you can get around all of that just by executing effectively a standard form contract with your processor or other controller that's based outside of the EU. Much easier to do it contractually with the people you're dealing with than to go through the DPC, to be honest with you. Privacy impact assessments and DPIAs. Facebook got into trouble there relatively recently. They were introducing a dating app, many of you might know. The plan was to have it introduced for Valentine's Day earlier this year. They gave the DPC, I think, 10 days notice of what they were going to do. It was kind of with, oh, by the way, we're going to do this, we're sure that's fine, isn't it? And the answer, of course, is no, it wasn't. The DPC essentially can give itself up to 3 months to review your DPIA. So giving yourself such a tight window of 10 days was never going to fly. And I know Facebook weren't happy. Absolutely coincidentally, nothing to do with the particular issue. I was having lunch with the data protection regulatory lawyer in Facebook. It had been planned before this dawn raid had occurred. So it was an interesting topic of conversation, because it was literally a couple of days after the DPC called this out. Facebook cancelled the app and it still hasn't been implemented, and I presume, I'm guessing they probably want to implement sometime before next Valentine's Day. But that's not just for Ireland, that's for the whole of Europe, because the app is, they've had to pull the launch, essentially because they didn't do the DPIA in time. The whole point of a DPIA under the privacy by design concept is that it starts at the ground floor. You don't do a DPIA as the last thing in a checklist before you roll out your app. You should actually be doing it at the start. A bit like the COVID contact tracing app. Again, much fanfare about how it was going to be launched in May, and then they were going to submit it to the DPC for approval, but and saying it was going to be launched in early June. But they don't know that because the DPC could have objections to that, and we could be 3 months down the line before those are fully teased out. DPC, admittedly, it's on the basis of the DPC asking for an extension of time, but the DPC is up to 3 months to consider DPIAs. Another common compliance issue, data subject rights requests. That's very run-of-the-mill. It's always going to be the case. I don't have any special magic about it. Bottom line is, request comes in, you deal with it, you get it out. I will mention a case shortly, which is suggesting that penalties for non-compliance might be increasing and increasing substantially. So I want to speed through this fairly quickly because I'm looking at the time there. I want to get in time for questions. Data breach responses, common compliance issues, lack of foreplanning. The time to respond to a breach is not when it happens. Have a breach plan in place. Many of you have plans in the IT end of things. You'll have plans for if the servers fall over, you'll have mirror sites, and you'll have, you know, ability to recover and so on and so forth. Same with a data breach. Have your plan in place before the breach. Another common thing, failure to recognize data security doesn't mean IT security. Data protection is about data. It's not about electronic data. It's about all data. Often missed. Sometimes it becomes the domain of the IT guys, and I appreciate from ISACA that's where that domain resides. But for those who have a remit outside of that in more of a compliance sense, it also means locks and doors, cabinets, you know, not exposing file and paper to prying eyes and so on and so forth. Common mistakes in implementing GDPR, failure to automate where possible. If you can automate a process, do, because this can be a horrendously expensive compliance area. There's a belief that GDPR prevents businesses from marketing or from collecting or processing data. The amount of times I have heard GDPR, we can't do this, why? Because GDPR. Anytime somebody says we can't do this because of GDPR, they are usually ill-informed. There's nearly always a way to achieve the goal in a compliant way of doing it. So if somebody says, no, we can't cause GDPR, it's usually because they don't want to achieve the goal or because they're misinformed. And I'm sorry for being blunt, but that's been my experience. Usually you can find a way to achieve the commercial goal whilst being compliant. And that's often because effectively a failure to properly drill down into a business commercial aims and getting hung up on specific technologies. Remember, GDPR is a legal regulation. It's not about a particular technology. You can't do it this way, maybe you can do it that way. Somewhere or other, the commercial goal will be achievable in some way. So where will the DPC focus next? So what the DPC was saying February last year, less than 18 months ago, much more remains to be done in terms of both guiding on proportionate and correct application of this principle-based law as appropriate. That was back in the day when the DPC saw itself, and possibly still does, as being guidance and training and light touch and so on and so forth. The view emanating from the Schrems case, and I've set it up there, the Advocate General, his view in last December was the supervisory authority is also required to react appropriately to any infringements of the rights of the data subject which it has established. In simple terms, the Advocate General was not impressed by the DPC's lack of proactivity in relation to Schrems' complaint, in relation to, and the DPC's tendency to push everything onto the High Court, and the High Court's tendency to push everything onto the Court of Justice of the European Court. They are basically saying the law is there, it's relatively clear, you know, get and enforce it, is the trend. So where is the focus going to be? The focus seems to be heading towards enforcement. As I say, the Schrems case is coming up in July 16th next. And if the full court follows the Advocate General's view, we might find a fairly toughened enforcement regime. So we're going to be looking at that very, very keenly. It's only about 5 weeks away. So, and lastly, some fairly frightening things if you are the controller. First case from last month. The Dutch District Court ordered that the Dutch Data Protection Authority has to compensate a data subject for its failure to enforce the GDPR. Light touch by the Dutch Data Protection Authority, didn't enforce the regulation. Dutch District Court said, well, this data subject has suffered loss because you haven't enforced. It's your job to enforce, and the Dutch DPA is being forced to compensate. Now, if that becomes a trend where courts are basically forcing regulators to do their job, then it's going to get it, the regulation, the enforcement is going to increase rapidly. And that's a trend in literally the last couple of months. That's the trend. Dusseldorf Labour Court. Now, this is a non-binding award and it is currently subject to an appeal, but this is the trend. It awarded €5,000 for a 3-month delay in furnishing a data subject access request. So subject access request came in, but the controller didn't respond with expedition, eventually did respond. The data subject complained to the authorities. And ultimately, the finding was, firstly, that the severity of non-material damage is irrelevant for purpose of establishing liability. In English, he didn't really have to suffer any loss. All that had to happen was for there to be a breach of the law. So there was always this notion in Irish law that you'd have to have damage, and even that some cases where the damages were too low to have any significance. That seems to be going out the window. The GDPR itself allows for non-material damage cases, and that's now being fleshed out. Secondly, the compensation should be in a deterrent amount. The point is to get compliance with the legislation, and therefore compensation should be in a deterrent amount. This guy suffered almost no damage for the fact that his access request wasn't responded to for 3 months. And it was inadvertent. It wasn't deliberate. Nobody was playing ducks and drakes with him or silly monkeys with him. It just wasn't high on the agenda of the controller. And it was accepted that this wasn't malicious. But the award was 5,000. Now, in fairness, the controller was a fairly substantial entity and able to afford it, and that was part of the reasoning. But if we see SMEs being fined €1,000 simply because they failed to respond to an access request for a month, you know, that will be a fairly severe thing. So we're open to questions, Fergal. Throw any of them at me, and Gail, I think, may have been answering some of them as we go along.
Actually, Fergal, do you mind if I just pop in there for a second? Because I think there's one quite interesting one that David might want to address with regard to the EU rep, just to clear that off. I think it was Connor was asking me, were there any outcomes yet by the Irish DPC in relation to EU representatives? But David, you might just explain where we were with other EU regulators. I explained to Connor that there was no outcomes by the Irish DPC as yet, but there were in other jurisdictions.
Yeah, I mean, there have been findings. First of all, the European Data Protection Board has clarified, I suppose, some of the positions as to what an EU rep can and can't do. There have been cases which have, for instance, found that the existence of the EU rep, for instance, doesn't remove liability from the controller. It doesn't even share liability, even though, for instance, in Spain, Spanish law allows for that provision. I think, I could be wrong, Gail, but I think Spain is the only country that's done that. But
yeah, no, you're right. Yeah.
But essentially, a bottom line is that the controller is still liable, but they must appoint the rep. And if they don't appoint the rep, they remain liable. And this is another breach. Now, if you're having €5,000 awards for effectively minor technical breaches, you know, there's nothing stopping a 5,000 award for somebody who claims to be affected by the fact that an Article 27 representative wasn't appointed. They don't have to show any damage or any, you know, significant impact from that. They simply have to show that there was a breach and that they were a data subject affected by that breach. So I suppose at its harshest, that's the risk. Any other questions or any more on that?
No, there's some other very interesting questions there. I suppose there's one in relation to if you're small. I forget who it was from there now, but maybe if they want to raise their hand and give it to Fergal, they can maybe come live if they want to. But basically, that if you're small, why would you be ignored? Why would you want to comply with this piece of legislation? The analogy was given about the guards out with their speed cameras. So if you want to maybe address that, that it's good governance, David, maybe.
Comply with either Article 27 or
no, just in general regard to the GDPR compliance in general.
I have the question here, Gail.
Okay,
I can just read it.
I think there's a very good reason if you're a small outfit as to why you should comply with GDPR, because you'd be personally liable, to be blunt. One section in the Data Protection Acts now, specifically in Ireland, but one section in Ireland, if you willfully breach certain portions of the Data Protection Act in Ireland, and presumably if you're ignoring GDPR, you'll be ignoring the Data Protection Act. You're not going to know which bits of data protection are which. If you breach certain sections of that, you can find yourself liable for some very substantial fines and indeed prison terms. If the company breaches it, and that's due to your willful neglect or your connivance, then you can be personally found liable. So, for instance, a director in a small company, a 5-man company, and the MD is asked by his underling, oh, should we get compliant with GDPR? And he writes off an intemperate email saying, no, couldn't be bothered. All this regulation, you can't make money. It's a waste of time. And then gets investigated, and somehow that comes out. He actually potentially is facing prison time. Now, I think when I say potentially theoretically in a jurisdiction that hardly ever sends company directors to jail for offences. So I don't want to over egg it. It's on the statute book. There is a risk, even if it's not a prison fine, a prison sentence, which I think, frankly, in this jurisdiction, even though it's on the books, is unlikely. But if you hold away in handcuffs, don't say he said I won't go to jail. But fines are definitely likely, and in particular in GDPR, the trend is that regulators are going to be forced to fine and fine heavily. The trend is that our light touch regulation is going to be called to heel by other regulators in Europe and the European Data Protection Board. We're probably currently in the phony war with regard to this still, but we're probably coming to the end of that.
I was actually replying to somebody there about the, how would the lack of a plan cause them a problem with regard to enforcement and audit. And I'm explaining, I think it's to, sorry, I can't actually see my screen and talk at the same time. Sorry, my glasses, I need new glasses. I was explaining that basically that I think enforcement will come through the supply chain, David. I think you would agree with me there. So lack of trust.
Enforcement will come, enforcement will come in several ways. It'll come from administrative fines. It may come from criminal fines under the Data Protection Act. I think that's less likely. It will come from civil litigation from data subjects. It will come from complaints to the Data Protection Commission and sanctions imposed by them, which might include non-monetary sanctions, stop your processing, so on and so forth. But it will also largely come from compliance. It will come in due diligence. Are you compliant with the Data Protection Acts and the GDPR? Please show us a copy of your Article 30 record. Please show us your model clause agreements for transferring data out to you. Please,
we seem to have lost a connection there to David. So just while we try to redo that, hold that while, and hopefully we'll get David back in a moment. So we'll just put up that poll to have a look at while we're getting back. David, are you back? I think I see.
I can address maybe the DPIA question that somebody had maybe while you were trying to get David back up, and the whole issue about privacy by design. In my view, privacy by design is probably a culture within the organisation, and the DPIA then is a tool to make sure that data protection and leading on the privacy rights of individuals is not forgotten about, and it's not an afterthought. I hope that answers the person's question. When David does come back online, I'll see if he's got time to address it. There was one other question in relation to the whole area of cookies and what cookies are necessary or are allowed in a cookies compliance banner. There's a case called the Planet 49 case, and basically, without going into a massive amount of details, we just don't have time. As long as the cookies that you're dropping are necessary, what I mean by necessary are cookies that will only allow the function of your website. It's not analytics, it's not preference, it's not anything where you're capturing anybody's data, and I hope that answers that question. I'm going to see if I can pick up a few more questions there while David is off.
Gail, there's one there that perhaps I could give to you.
Sure.
Does the right, this is from Lorraine Carmody, does the right of data portability relate to email providers? For example, can you request to migrate emails to Gmail?
I think I was going to leave that to David, if that was okay, Fergal, because I think we probably have differing views on it. So I wanted him to address that one. I'm sorry, Lorraine. And if we don't get David back, if you want to email us at the email provided, I'll answer that in greater detail later at a later stage.
Yeah, I think we have lost David. So I'll just
shoot a few more at me there if you want to.
Pardon?
If you want to give me one or two more questions, I'll try and address some of the others. There's one or two more there that I see that I was answering, but let me think.
Okay, I'll just give the results of the poll while you're looking at that. My organisation is how compliant. The majority is 80%, quite quickly followed by 100%, which is good to see. Area of greatest difficulty, carrying out DPIAs out in front, followed by staff awareness second. But we'll share the results of that with you, which you can see on your screens now. David, I think you're back.
I am. We've had basically a power outage of all things. So there's just it's the law of the unexpected. So we seem to be fine.
Great.
Now, so if there's any more questions, and sorry, I was busy sorting that for 2 minutes. If there's anything else, feel free to put them at me.
There was actually a question at the very, very beginning of the Q&As. I saw it coming in. Somebody was asking if there was a published list of
I see it here. Someone called Michael. Lack of a plan has been called out.
I just want to point out a very, very useful resource, which is www.gdprhub.eu, which is a wiki that is being created. It's being populated by community responses, and it's a digest of fines issued by supervisory authorities across the EU, and it's also a digest of all the decisions and both court decisions and supervisory authority decisions all combined together, and it's really very, very useful. So that's www.gdprhub.eu. Would recommend that to anybody.
David, there was one question there about data portability and emails, which you might address for Lorraine, please. I dealt with it, but I said I'd like you to.
Okay. So what was the question?
It was in relation to whether or not data portability was applicable to email.
I'm not aware of any decision on it, but on the face of it and on the wording of the GDPR itself, it should be, because it said, provided, of course, there are emails that are coming from the data subject. Because bear in mind, in order for data to be caught by the data portability provisions, it has to be data that's provided in electronic format by the data subject and intended to be processed by the controller, or I guess the processor on behalf of the controller, in electronic format. So we're talking about electronic stuff being processed electronically and coming from the data subject. But if that's the case, then yes, it would, I think, in theory, be captured by it. I have to say it's something of a Cinderella thing. The drive behind it was for things like swapping, telephone providers and, that sort of stuff, where essential information could just be ported over. That was the thinking behind it. It wasn't really intended, I think, to transfer complex correspondence and so on and so forth. But on the wording of it, which is personal data provided by the data subject electronically and being processed electronically, to my mind, it would fall within that definition. And it shouldn't be incapable of being captured by controllers or processors, because it is coming in electronically, so therefore it can be worked on electronically.
While you were missing there, I answered the question in relation to a DPIA and versus in baking privacy into an organization, as in privacy by design. I explained that I felt that privacy by design was a culture within the organization, and a DPIA was a project, was a tool, so that the whole project could tell the story with regard to data protection, its risks, and compliance issues going forward. I don't know if you want to add to that.
I'm not quite sure that the point.
Well, should the DPIA, there's one question here that's I'm looking at it, should a DPIA be part of a procurement process? And I have said yes to that. And another lady asked me to explain the difference between data or privacy by design and DPIAs.
Okay, so so essentially privacy by design is fundamentally, I suppose, a way of thinking that you hardwire the privacy into your initial thoughts. I read an absolutely wonderful article on LinkedIn by Ron De Jesus. If you find Ron De Jesus on LinkedIn, you'll see his article. But essentially, he was talking about, in practice, how does that work? It works by buy-in from management. It works from being in part of the product design teams, making sure that when products are being developed, that the compliance person is aware, not necessarily in daily meetings, but certainly in weekly or monthly meetings, so that they can see the progress of the project and they can see what the privacy issues are, as opposed to the old model whereby the product was developed and then somebody runs it past the compliance guys. So essentially, that's the thinking behind it. A DPIA is a separate thing. It's part of it. But if you think of privacy by design as being the concept and a DPIA being a tool, the tool of the DPIA essentially is effectively an audit of sorts to see, or an assessment of sorts to see how is our proposed project, processing, product, whatever it is, how is it going to affect data subjects' rights, and how can we mitigate that? Essentially, it's simply I suppose, a risk assessment with regard to that. So one is as you say, one is a concept and an overarching concept, and the other is a tool for use in a specific project.
And so I'd like to add that it shouldn't be a tick box exercise. It shouldn't be an afterthought. In order to be able to in-bake privacy or data protection within your organization, you need to think about this at the very beginning of a new activity. And you probably should review most of your activities where data is flowing.
Yeah, I mean, there are specific times when a DPIA is required. Particularly where there's new technologies being used, when it's likely to result in high risk to rights and freedoms of data subjects, there should be a DPIA. But I think that even without a DPIA, there should be what we used to call a PIA, or privacy impact assessment, for even processing that doesn't meet that test. I would say if you're doing anything new or different, you should really have at least a quick kind of privacy impact assessment. But if it's going to potentially to result in a high risk to the rights and freedoms of data subjects, or in English, if it's going to have a significant impact on data subjects, then you're definitely going to need a data protection impact assessment, or the one that's mandated under the GDPR.
Okay, well, I think we'll wrap it up at that, David. Thank you very, very much for all that information, and to Gail too. It was really, really very informative, and we've already got some good feedback, so I'm delighted with that. I hope everybody enjoys the rest of the evening. Thank you again, guys, and hopefully we'll talk soon. And with that, we'll close the show. Thank you very much.
Thanks so much, and there's contacts up there on the web. I think, Fagan, also we're sending the slides out to people as well, are we?
Yes, we are indeed. Yeah, we'll make the slides available, and there'll be no problem with that. Great. Okay. Thanks very much, everybody.
Thanks, everyone, for your attention. Thank you very much.
Thank you.
Bye.